Hello, everybody, and welcome to History/Law Bite number 294, dated July 25th, 2021. I'm Walter, your mobile historian and blue-collar scholar. Thank you for tuning in. Before we begin, I'd like to invite you to subscribe to my YouTube channel, Ware Shelton, MA. Just click that little red subscribe button on your screen, as well as the little notification bell next to it. In doing so, you will receive updates when I post new videos. Thank you in advance. This History/Law Bite is entitled Ware versus Hylton, 3 U.S. 199, 1796. Ware versus Hylton was one of the Supreme Court's relatively few decisions dating from its first decade of life. That's the period between 1789 and 1799. During that decade, the Supreme Court dealt with a significant amount of legal issues that had not yet been resolved from the American Revolution, which at the time of this decision was just a little over a decade behind them from when the Treaty of Paris of 1783 was signed, which of course concluded the war. Lots of legal issues were left unresolved, with the Treaty of Paris and the implementing of that treaty by the United States and Great Britain. Some of the issues were resolved with the Jay Treaty of 1795. Other issues were not. And the Supreme Court laid to rest quite a few of them, and those that continued into the 19th century were resolved by the War of 1812. But that is for another video. Here we focus on Ware versus Hylton. And we begin in the same way that the U.S. Supreme Court does. All rise. The Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated. Mr. Chief Justice, and may it please the court, we present Ware versus Hylton. So as I said, this is a case based on the applicability of the Treaty of Paris of 1783 and a state law whose provisions ran contrary to the terms of the Treaty of Paris, Of course, the Treaty of Paris of 1783 concluded the American Revolution, brought that to an end once and for all. However, it wasn't quite clear as to whether or not, states and the federal government would fully honor the terms of that treaty. This case provides you with a great example of that, folks. So, in this case, we see the state of Virginia, which had enacted a law during the American Revolution that provided for the confiscation of debts owned by British nationals, thus prohibiting their repayment. Their rationale for this law was that these debts were owed to enemy aliens, and thus did not have to be repaid. So with the end of the war and the signing of the 1783 Treaty of Paris between Britain and the U.S., Article 4 of the Treaty of Paris stipulated that such debts owed to parties on either side of the Atlantic were legal and valid and should, quote, meet no lawful impediment. So, in this case, a Virginia resident owed a valid debt to a British creditor. But due to the Virginia law discharging these debts owed to British creditors, the British creditor obviously found it very difficult in getting repaid. So as such, he filed suit in the U.S. Circuit Court for the District of Virginia for the recovery of the debt, basing his legal argument on Article 4 of the 1783 Treaty of Paris. Okay? So the legal issue facing the Supreme Court of the United States is quite simple. Did Article 4 of the 1783 Treaty of Paris override the Virginia debt confiscation statute, which obviously ran completely contrary to the language of Article 4 of the Treaty of Paris? The Supreme Court of the United States, in a 4-1 decision, delivered, of course, at that time in their seriatim format, which means that each member of the court wrote an opinion, simply ruling in favor of one of the parties. At this time, it was very rare, almost non-existent, to have a single opinion of the court, where one justice writes an opinion and those who agree with him go along with it. At this time, each justice wrote a single opinion deciding he should win, okay, or that party should win, okay? So seriatim pretty much disappeared with John Marshall being appointed Chief Justice in 1801. Remember, this is 1796, okay? So in a 4-1 decision, so 4 members of the court versus 1, okay? All in the majority, all right, sided with our petitioner, Ware, ladies and gentlemen. The court overturned the holding of the Circuit Court for the District of Virginia and ruled on the following points of law in favor of our petitioner, Ware. First, the court ruled that the Supremacy Clause, if you've never heard of that, located in Article 6, Section 2 of the U.S. Constitution, made the language of the 1783 Treaty of Paris authoritative over the Virginia law to the contrary, all right, which was in turn voided. Therefore, state laws which conflicted with the implementation of federal treaties were unconstitutional, folks. Number 2, that the United States was bound by the laws of nations in its modern state of purity and refinement, and thus Virginia's law must fall, as it did not comply with said international standards. Additionally, the people had a duty to comply with treaty requirements, and thus even if Virginia's actions were customary under international law, the Treaty of Paris would still have primacy over the situation, okay? And last but not least, number 3, all state laws which run contrary to the language of any federal treaties essentially must fall prostrate before them, all right? Summed up, the Virginia law was unconstitutional because it directly violated the clear language of Section 4 of Article 4, of the 1783 Treaty of Paris, folks. Simple, right? I agree. So I'll read a brief excerpt from the opinion, the primary leading opinion in this case, all right? It says, if doubts could exist before the establishment of the present national government, they must be entirely removed by the 6th article of the Constitution, which provides that all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. There can be no limitation on the power of the people of the United States. By their authority, the state constitutions were made, and by their authority, the Constitution of the United States was established. And they had the power to change or abolish the state constitutions or to make them yield to the general government and to treaties made by their authority. A treaty cannot be the supreme law of the land, that is, of all the United States, if any act of a state legislature can stand in its way. If the Constitution of a state, which is the fundamental law of the state, and is paramount to its legislature, all right, must give way to a treaty and fall before it, can it be questioned whether the less power, an act of the state legislature, must not be prostrate? It is the declared will of the people of the United States that every treaty made by the authority of the United States shall be superior to the Constitution and laws of any individual state, and their will alone is to decide. So the judgment of the Supreme Court here was to reverse the Circuit Court for the District of Virginia. So the legacy of this case is pretty simple and straightforward, folks. This was the very first time in the history of the Supreme Court of the United States that the court invoked the Supremacy Clause in the U.S. Constitution for any purpose at all, and arguably the first time the court invalidated a state law that violated a federal law. Here, the Virginia law violated a U.S. treaty, okay? And that was a clear violation of the Supremacy Clause of the Constitution, giving primacy to federal law over state law when the two come into conflict, providing that the federal law is constitutional, which it clearly was, okay? So, I'll also add that there were a lot of A-list individuals of the day connected with this case, including advocates Sir Patrick Henry, give me liberty or give me death, and John Marshall. All right, even though ironically Marshall represented the losing side here. We all know that Marshall would of course be appointed by President John Adams just 5 years later as Chief Justice in 1801. All right, so again, folks, that is Ware versus Hylton. All right, and our citation is 3 U.S. 199, 1796. So if you have any questions or controversies, you can leave them down below. I'll be happy to answer them. And before I go, real quick, just a quick summation of the holding of the court. In this case, federal treaties have legal precedence over state laws to the contrary. Okay? So again, any questions or controversies, leave them down below. I'll be happy to answer them. If you have not subscribed to my YouTube channel yet, don't forget to do so before you leave. And if you like this video or gain some knowledge or insight of any kind from it, drop me a like. That will be appreciated more than you'll ever realize. All likes and all subscriptions matter. Thank you in advance. Take care, stay safe out there, and I will talk to you at the next video. Peace.